Yeah, so before I delve into this topic, I think it would be helpful to just set out some of the background and how we resolve financial remedy in matrimonial finance settlements. So to start with, in 2001, and sorry, there's going to be a bit of a history lesson here, but in 2001, in the seminal case, we decided to judge the fairness of settlements against what we call a yardstick of equality. So are we more or less hitting the 50% equal division mark? You know, what's mine is yours, in a sense. From there, we started adding additional criterion to the fairness assessment. Are we meeting needs? Are we compensating for relationship-generated disadvantage? So commonly with that latter example, one might think of someone who has given up their career in order to look after kids, and as a result, on financial settlement, we will look to ensure that their needs are met, accounting for the fact they've not been able to build a pension or a mortgage, etc. So one can see that with that quite broad brush, generous principles, that if you are the person who is economically weaker, or conversely, if you're the person who's economically stronger, you're facing a settlement that's quite generous to that economically weaker party. And as a result, England and Wales have gotten an international reputation for being the divorce capital of the world. Since the millennium, we've been trying to reduce what we're adding to this pot for equal sharing. And we start coming up with this concept, or we start formalizing the concept of non-matrimonial property, which should not ordinarily be subject to the sharing principle. So we've got matrimonial property, equal division. We then got non-matrimonial property, which would be outside of that equal division and retained by the person who generated that wealth. What matrimonialisation is the term of art by which something which is non-matrimonial goes to being matrimonial. And the difficulty the court has is in how you essentially categorize that asset. And further, once you've categorized the asset, to what proportion do you essentially benefit or credit the person who originally had the non-matrimonial wealth, which has since become more matrimonialized? There was a seminal case this year, Standish and Standish, which reformulated the factors that we look at. But before I delve into that, it might just help to give a bit of context to the case. So in this case, Mr. Standish transferred £80 million worth of investments to his wife in the latter years of marriage. The source of those investments were non-matrimonial in nature. Prior to their transfer, if they had gotten divorced at that time, the starting point would have been that would have been excluded from the pot. But because he had transferred them to his wife was saying, well, hang on a moment, you've gifted them to me. And the court found that they were gifted essentially without reservation of benefit. And she was saying, well, that should be subject to equal sharing, part of the sharing principle. The context for the transfer was, and this is going to apply to a lot of high net worth cases, was part of inheritance tax planning. So essentially, in trying to manage the family's finances and mitigate the tax consequences for how they held their wealth, and to avoid it being held unilaterally by one party, husband had taken some advice and transferred some of the shares to his wife to mitigate the tax. And in due course, potentially, they would be put into a trust once a certain amount of time had passed. But the court was not convinced that he had essentially intended to retain any benefit, and so found that they were gifted. The crux of the issue, is whether there should be, as I said before, a credit for the fact that the source of the asset, regardless of the fact that the wife's name was on the title for those shares, should be given any credit back to him. And the court found that yes, it should. And the factors that the court determined in looking at that, into what should drive and be relevant in considering matrimonialized assets, are things like, to what extent has it been mixed and mingled, and what would fairness justify? Are we talking about a significant proportion of the party's assets that we would call, generated through non-matrimonial endeavor? Does that justify an evidential exploration into those assets? And then finally, is it something like the family home, which you would usually put as a category of its own, although the court will still credit unilateral unilateral contributions or more significant contributions by one party into the family home. So the problem with all those factors and the very much finger in the air math that the court does is that it's incredibly discretionary. And a lot of people who are doing wealth planning or who, and increasingly common, particularly with millennial or Gen X, inherit large amounts of wealth, are going to face is that if they're already married or planning to get married, it's very hard for them to have any certainty as to how the court will deal with their assets. It's also worth highlighting that regardless of the court's categorization of your assets, matrimonial, non-matrimonial, matrimonialized, the court can still invade non-matrimonial assets or matrimonialized assets to a greater proportion if it's necessary to meet needs. So how do you get certainty in your financial settlement? Well, at any stage where you have an influx of wealth or change the way you hold wealth, we would strongly advise that you get a nuptial agreement, because the court will give great weight to nuptial agreements so long as certain legal safeguards are met. And this will ensure that you have certainty going into, or if you were to go into any financial separation.